Well, good morning, everybody. Carrying straight on from where we left off, which was obviously the sentencing of Brendan. Next comes section E, post-conviction proceedings. Dassey moved for post-conviction relief. A hearing was held over 5 days beginning on January the 15th, 2010. The hearing included testimony of one of Dassey's trial attorneys, the prosecutor, a social psychologist, Kaczynski, O'Kelly and Richard Leo. That's a very important name to remember. We'll discuss this further on. An expert in false confessions. The Circuit Court denied Dassey post-conviction relief on December the 13th, 2010. Dassey appealed, and on January the 30th, 2013, in an unpublished per curiam decision, the Wisconsin Court of Appeals affirmed his conviction. The Wisconsin Supreme Court denied Dassey's petition for review on April 1st, April Fool's Day, 2013. Dassey filed the present petition for a writ of habeas corpus pursuant to 28 U.S.C. SS 2254 on October the 20th, 2014. After Dassey consented to have a magistrate judge resolve his petition, the court reviewed the petition in accordance with Rule 4 of the rules governing Section 2254 cases and ordered the respondent to answer to the petition. The respondent likewise consented to have this court resolve the petition. Therefore, in accordance with 28 U.S.C., having received the consent of all parties, this court may order the entry of judgment in this case. Briefing is concluded and the matter is ready for resolution. Okay, then we get the next sort of big bulk of his decision. Number 2, standard of review. This is obviously very interesting. With the passage of the Anti-Terrorism and Effective Death Penalty Act, Congress dramatically changed the federal court's role in reviewing the judgments of state criminal courts. EDPA erects a formidable barrier to federal habeas relief for prisoners whose claims have been adjudicated in state court. Under 2254, a federal court may grant a writ of habeas corpus only when the state court's adjudication of the petitioner's claim on the merits, 1, resulted in a decision that was contrary to or involved an unreasonable application of clearly established federal law as determined by the Supreme Court of the United States, or resulted in a decision that was based on an unreasonable determination of the facts in light of the evidence presented in the state court proceeding. Under Statute 2254, a state court decision is contrary to clearly established federal law if the state court applies a rule different from the governing law set forth in United States Supreme Court cases, or if it decides a case differently than the United States Supreme Court has done on a set of materially indistinguishable facts. A state court's decision is contrary to federal law if the state court either incorrectly laid out governing Supreme Court precedent or, having identified the correct rule or law, decided a case differently than a materially, factually indistinguishable Supreme Court case. Under the unreasonable application clause, a federal habeas court may grant the writ if the state court identifies the correct governing legal principle from the United States Supreme Court's decisions, but unreasonably applies that principle to the facts of the prisoner's case. The Supreme Court's holding must provide a clear answer in the petitioner's favour, novel arguments for the expansion of constitutional rights or arguments dependent upon the decisions of any court other than the United States Supreme Court do not merit federal habeas review. Moreover, a court may rely upon only the Supreme Court's holdings, not its dicta. Under 2254, a state court's decision involves an unreasonable determination of the facts if it rests upon fact-finding that ignores the clear and convincing weight of the evidence. If the state court adjudicated the petitioner's claim on its merits, a federal court cannot grant a petitioner habeas relief merely because the federal court disagrees or even strongly disagrees with the state court's decision. A federal court is required to afford substantial deference to the findings and decisions of the state court. For a federal court to grant habeas relief, a state court's decision must not merely be wrong, but so wrong that no reasonable judge could have reached that decision. That sentence is oft used by Laura Nyrider at the various presentations that you go to, so watch out for that one. I'll just read through that again. For a federal court to grant habeas relief, a state court's decision must be not merely wrong, but so wrong that no reasonable judge could have reached that decision. More specifically, to grant relief, the petitioner must meet the demanding but not insatiable standard of showing any reasonable fact finder would reach a conclusion other than that reached in the state court. This substantial restraint upon the authority of federal courts is intended to further the principles of comity, finality, and federalism. The limitations are designed to ensure that state court judgments are accorded the finality and respect necessary to preserve the integrity of legal proceedings within our system of federalism. Moreover, the Supreme Court has said that state courts are adequate forums for the vindication of federal rights. State judges, like federal judges, have the solemn responsibility to safeguard constitutional rights, and there is no intrinsic reason why the fact that a man is a federal judge should make him more competent or conscientious or learned than his neighbour in the state courthouse. I wonder if she's come across Judge Angela Sukovich. Makes you wonder, doesn't it? Federal habeas review thus exists as a guard against extreme malfunctions in the state criminal justice systems, not a substitute for ordinary error correction through appeal. Section 3, Dassey's claims. Dassey's petition for a writ of habeas corpus contains two claims for relief. First, Dassey claims that he was denied his Sixth Amendment right to the effective assistance of counsel. Second, Dassey claims that his March 1st, 2006 confession was obtained in violation of the Fifth Amendment. Section A, ineffective assistance of counsel. In all criminal prosecutions, the accused shall enjoy the right to have the assistance of counsel for his defence. This includes the right for a defendant to retain an attorney of his choice, to have an attorney appointed to represent him if he cannot afford an attorney, to be represented by an attorney whose actions are not impacted by a conflict of interest, and to receive the effective assistance of counsel. When a convicted defendant alleges that his Sixth Amendment right to counsel was violated due to the conduct of his attorney, the claim most commonly alleges that counsel was ineffective under Strickland. Under Strickland, a defendant must demonstrate both that his attorney's performance was deficient and that the deficient performance prejudiced the defendant. Strickland encompasses a wide variety of attorney errors and misconduct. In its decision granting Kaczynski's motion to withdraw from the case, the trial court found that Kaczynski's performance was deficient under Strickland when he allowed investigators to interrogate Dassey without an attorney present. On appeal to the Wisconsin Court of Appeals, however, rather than seeking relief under Strickland, Dassey sought relief under the more forgiving Sullivan standard, arguing that Kaczynski acted under a conflict of interest when he assisted the prosecution in obtaining evidence against Dassey. Dassey argued that Kaczynski's conflict of interest adversely affected him because it led to Kaczynski's failure to attend the May 13, 2006 interrogation. That uncancelled interrogation led to Dassey's recorded phone call with his mother, which was used to his detriment at trial. The Wisconsin Court of Appeals found that Dassey failed to show that Kaczynski had a conflict of interest. It also concluded that Dassey had failed to draw a viable link between Kaczynski's actions and any demonstrable detriment to him. It stated that there was no indication that Kaczynski's alleged conflict had any adverse effect at the suppression hearing, nor did the search warrant obtained pursuant to the information Kaczynski provided to the prosecution yield any evidence. It did acknowledge that the jury did view a brief video clip of Dassey's post-interview telephone conversation with his mother. Quote, significantly, though, the state properly introduced it only to rebut Dassey's testimony on direct that the acts to which he had admitted didn't really happen, and that his confession was made up. The Court of Appeals concluded that voluntary statements obtained even without proper Miranda warnings are available to the state for the limited purpose of impeachment and rebuttal. Excuse me. Dassey set forth 3 arguments regarding the Wisconsin Court of Appeals decision regarding his ineffective assistance of counsel claim. First, he argues that the court's conclusion that Kaczynski did not labour under an actual conflict and that any conflict did not adversely affect the trial was an unreasonable application of clearly established federal law. Second, he argues that the Court of Appeals made an unreasonable finding of fact when it found that the state had used the May 13th telephone call between Dassey and his mother only to cross-examine Dassey, when in fact the state used the call at least 3 times, including during closing argument, to neutralise Dassey's alibi. Thirdly, Dassey argues that the decision applied the wrong rule of law, the Fifth Amendment Miranda impeachment rule, to assess his Sixth Amendment ineffective assistance of counsel claim. I particularly like this bit. Number 1, conflict of interest. Although it probably does not need to be stated, it will be. Kaczynski's conduct was inexcusable, both tactically and ethically. It is one thing for an attorney to point out to a client how deep of a hole the client is in, but to assist the prosecution in digging that hole deeper is an affront to the principles of justice that underlie a defence attorney's role in that adversarial system. That said, Dassey's attempt to characterise Kaczynski's misconduct as a conflict of interest under Sullivan is misplaced. In Sullivan, 2 attorneys jointly represented 3 co-defendants, all at separate trials. The Supreme Court concluded that if the defendant did not object to the joint representation, representation at trial, he may prevail on a claim that his right under the Sixth Amendment to the effective assistance of counsel was violated only if he demonstrates that an actual conflict of interest adversely affected his lawyer's performance. That requires a showing that his counsel actively represented conflict in interests. However, unlike a claim under Strickland, no showing of prejudice is required. I must admit, as a little aside, I find it very odd that you have to, the judges and the courts are trying to decide, I've sort of put in the position of, if that had happened, then there'd have been a different outcome. It's like when you watch a game of football, either side of the Atlantic, how do we know how sort of bad a referee's decision was in the final outcome of the game? How would things have changed? We don't know because it never happened that way. But anyway, let's move on. Some federal courts of appeals interpreted Sullivan as applying to various types of conflicts other than those involving the representation of multiple clients. And there's a whole load of examples. Let's just run through them. Summerlin versus Stewart, romantic entanglement with the prosecutor. Never heard that before. Pirillo versus Johnson, obligation to form a client. Conflict of interest. Freund versus Butterworth. And Garcia versus Brunel, job with the prosecutor's office. Let's go the right way, Paul. That's better, job with the prosecutor's office. United States versus Sion, fear of antagonizing the trial judge. United States versus Mitchell, teaching classes to IRS agents. Manault versus Reed, obligation to form a client. United States versus Young. United States versus Hearst. Book deal. However, in Mickens versus Taylor, the Supreme Court stated that the language of Sullivan itself does not clearly establish or indeed even support such expansive application. As stated in Mickens, Sullivan stressed the high probability of prejudice arising from the concurrent representation of multiple clients and the difficulty of proving that prejudice. Not all attorney conflicts present comparable difficulties. The purpose of the Sullivan exception to the ordinary requirements of Strickland is to apply needed prophylaxis in situations where Strickland itself is evidently inadequate to assure vindication of the defendant's Sixth Amendment right to counsel. In his argument to this court, Dassey asserts that there can be no doubt that Kaczynski laboured under an actual conflict, but he never explicitly identifies the nature of Kaczynski's alleged conduct. The closest Dassey comes is when he asserts the problem is that Kaczynski actively and concurrently worked for two masters, the prosecutor and, or often at the expense of, his own 16-year-old client. Dassey never identifies any sort of relationship that Kaczynski had with the prosecutor that establishes a conflict of interest in the sense that the term is generally used. Kaczynski was not concurrently employed by the prosecutor's office, did not have any personal relationship with the prosecutor's office, nor did he have any financial or other interest in the work of the prosecutor's office. I must admit, I find that beggars belief, but anyway. The case upon which Dassey primarily relies is an unpublished district court decision from the Eastern District of Michigan that does not even refer to Sullivan. In that case, while entertaining the premise of the petitioner's argument that a defence attorney who chooses to assist the prosecution has a conflict of interest, the court quickly rejected its merits. Thus, in addition to being non-precedential, this case cannot be read as endorsing an expansion of Sullivan in the manner Dassey suggests. In another case, the defendant pled guilty to various crimes and was sentenced to death. The Court of Appeals for the 10th Circuit affirmed the District Court's decision to grant Osborne's petition for a writ of habeas corpus. The court said, a defence attorney who abandons his duty of loyalty to his client and effectively joins the state in an effort to attain a conviction or death sentence suffers from an obvious conflict of interest. The court continued, in fact, an attorney who is burdened by a conflict between his client's interests and his own sympathies to the prosecution's position is considerably worse than an attorney with loyalty to other defendants, because the interests of the state and the defendant are necessarily in opposition. These statements would seem to strongly support Dassey's position that an attorney who works to facilitate his client's conviction acts under a conflict of interest. However, Osborne, this case that I'm on about, not only predates AEDPA, but also another case, Mickens, where the Supreme Court made it clear that Sullivan was clearly established federal law only with respect to conflicts of interest resulting from the concurrent representation of multiple clients. Finally, Osborne was not strictly a Sullivan conflict of interest case. The court relied upon the general rules set forth in Sullivan, Strickland, and United States to conclude that Osborne's rights under the Sixth Amendment were violated. Specifically, the court stated, we base our conclusion that Osborne did not receive effective assistance of counsel on the clear evidence that the process by which he pled and was sentenced to death was not adversarial and therefore was unreliable. That principle is taken from Strickland. Thus, it appears that Osborne was more accurately a Strickland case, and statements that might be seen as emerging from Sullivan were merely corroborative to the decision. The Supreme Court has never held that the Sullivan standard applies to the sort of purported conflict Dassey identifies here. In fact, the court in Mickens expressly stated that it is not clearly established that Sullivan applies in any context other than the conflicts resulting from the concurrent representation of multiple clients. Thus, Sullivan is inapplicable here. Because Dassey may obtain relief under 2254 only when the state court decision was contrary to or involved an unreasonable application of clearly established federal law as determined by the Supreme Court of the United States, the Supreme Court statements in Mickens made it clear that this court is prohibited from granting Dassey the relief he seeks now. Relief under the Sixth Amendment may be found, if at all, only under Strickland. Thus, the court considers whether it might be appropriate to reconstrue Dassey's ineffective assistance of counsel claim as arising under Strickland. So we get the fact that the judge is saying to the defence lawyers, are you sure you're citing the right cases? Let's consider if you did it under Strickland. The respondent argues that it is not, although in both the Court of Appeals and in his petition for review to the response in Supreme Court, Dassey repeatedly referred to his claim regarding Kaczynski's misconduct as one of ineffective assistance of counsel. He never actually made a Strickland argument. Dassey's only discussion of Strickland in the Wisconsin Court of Appeals in the context of Kaczynski's actions was when he asserted even Strickland itself establishes that when defence counsel breaches the duty of loyalty, as Kaczynski unquestionably did here, then he operates under a conflict of interest governed by Sullivan. What the court actually said in Strickland was the inverse, that if a defence attorney operates under a conflict of interest, he breaches the duty of loyalty to his client. Although a claim of ineffective assistance of counsel is often synonymous with a Strickland claim, courts have used the term to describe both Strickland and Sullivan claims. But the claims are distinct. Naturally, one might wonder what difference it makes if an argument for relief for a violation of the Sixth Amendment is under Sullivan or Strickland. Why not just view the matter broadly, as the court arguably did in Osborne, and focus on the general Sixth Amendment consideration of whether the result of the particular proceeding is unreasonable because of a breakdown in the adversarial process? The answer lies in AEDPA and doctrines set forth in case law that restrain a federal court's authority to correct errors in state criminal proceedings. It is not only presumed that state courts are capable of protecting constitutional rights, but also that state judges will adhere to that solemn responsibility. Federal courts are bound to respect the decisions of state courts and the finality of their judgments. As part of the policy of ensuring that federal intervention occurs only as a last resort, the prisoner must have given the state courts a meaningful opportunity to pass upon the substance of the claims later presented in federal court. That requires that he articulates both the operative facts and the controlling legal principles on which his claim is based. There is certain commonality between the Sullivan claim Dassey made and the Strickland claim he could have made. Skipped a bit, sorry. He could have made, noting that a conflict, let's start that again, that he could have, under Strickland claim that he could have made, noting that a conflict of interest may be represented under both Strickland and Sullivan. As noted above, each constitutes a violation of the Sixth Amendment that can be referred to generally as ineffective assistance of counsel. The argument Dassey made in the state courts calls to mind the same Sixth Amendment right implicated under Strickland. Each requires proof of a harm varying only in the amount of harm, adverse effect versus prejudice, that the petitioner must prove. Proceeding under Sullivan places a lighter burden on the defendant than Strickland because demonstrating an adverse effect is significantly easier than showing prejudice. Dassey's Sullivan claim and his plausible Strickland claim are also based on the same facts. However, the court finds that it need not consider whether it may, consistent with the rules regarding exhaustion and fair presentment, reconstrue Dassey's Sullivan claim as a Strickland claim. Crucially, Dassey never asked this court to consider whether Kaczynski rendered ineffective assistance under Strickland. Indeed, he acknowledges a distinction between a Sullivan and a Strickland claim when he emphasises that demonstrating an adverse effect under Sullivan is significantly easier than showing prejudice under Strickland. Even after the respondent noted that Sullivan was not clearly established federal law for the claim Dassey presented, Dassey made no argument that his claim ought to be alternatively construed under Strickland. Dassey's arguments have been consistently and exclusively under Sullivan. In the absence of any request from Dassey, the court finds it inappropriate to reconstrue his Sullivan claim as a Strickland claim. Such extraordinary action would be outside the permissible bounds of judicial action, especially given the policies that circumscribe the role of federal courts in reviewing state court convictions. In short, the Supreme Court has never recognised misconduct such as Kaczynski's as a conflict of interest under Sullivan. Therefore, federal law prohibits the court from granting Dassey habeas relief on this claim. Although Kaczynski's misconduct might support a claim for relief under Strickland, Dassey never made this argument to the state courts or to this court. Consequently, federal law likewise prohibits the court from considering whether Dassey would be entitled to habeas relief on this alternative basis. Well, that was pretty heavy going, but I think the crux of the matter is the fact that the judge is saying, I'm trying to be fair here, but I cannot go against established rules. EDPA, you could have come under Sullivan or Strickland. You chose the Sullivan. I think we're getting the sense that, I don't know about you, but I get the sense that this judge is being very fair. He's looking at the facts. He's judging it based on what a judge should do. And as I say, not a bit like Judge Angie. Anyway, well done for sticking through 30 minutes of that. But I think it's quite important to understand exactly, we all hear that Judge Duffin, decided in favour of Brendan. Whoopie-doo. Well, yes, he did ultimately, but there are aspects of that where he was being, in most people's assessment, he was being perfectly fair. He was saying, this is what I can do, this is what I can't do. We just have to live with that. Certainly, I think if most people had their way, they would certainly try and amend the EDPA ruling, or at least get the judges to interpret EDPA in a slightly different way. It still beggars belief that it's referring to anti-terrorism and effective death penalty. Well, neither anti-terrorism or death penalty applies to Brendan Dassey, so it does seem a bit bizarre that they're applying this EDPA standard. Anyway. We'll carry on shortly. Just to let you know, hoping to do a live later on this evening, this afternoon, 4 o'clock Central Time, with Mr. Millbilly, who's got some really interesting stuff as usual on his channel. So we'll catch you soon. Bye for now.